being pretty nitpicking. He is drawing a lot of fine lines. He's testified he was upset about her leaving.
It seems to me the cross-examination isn't limited to asking blunt questions. I certainly have the right to ask questions.
Your Honor, there is law to the effect that cross-examination of the defendant has to be more limited in scope than that of other witnesses and is not to extend much beyond his direct. And I think there's a section in the penal code that says that. I think counsel is making his point. I'm not trying to cut him off completely, but it appears to me that he's going off on a lot of tangents here that are time-consuming and confusing to the jury and not relevant. And there are also matters that he testified about already. He already said he was upset when she left.
Upset is different than angry.
Well, I'll submit it, Your Honor.
We're getting into this tone of voice thing, and that's kind of difficult. I think you can just ask him if he was angry.
Okay. Mr. Jackson, when you contacted Bonnie Lane, were you angry about Lavita leaving?
I suppose I was angry, yes.
Did you contact any of her friends looking for her?
I'm trying to remember. I think I talked to Jerry. I can't remember if I talked to Jerry Lane or not. I'm not sure. And I might have talked to Loretta.
Okay, that's Loretta Winberg.
Yes.
And were you angry when you spoke with her?
Yes.
Did you threaten Lavita at all during that conversation?
Objection, Your Honor. May we take this up at the bench?
Yes, I think we better do it.
Your Honor, I make a motion for mistrial. Again, counsel once again stepped across the bounds of that protective order. And if he wants to go into this matter, we made it clear to him over and over again that he should be brought up out of the presence of the jury. If he wants to bring this stuff up, there's ample opportunity to do it without the jury being present. And I think that's directly in contradiction to the prospective order. He's well aware of mine.
If that's what the protective order is, I apparently don't understand it. Because it seems to me that the threats that the defendant made to her, showing he had to threaten her, is a different matter than her state of mind, his state of mind.
You're asking whether the defendant threatened his wife at this time?
Yes.
I don't see how he could threaten her because she wasn't there.
That's correct.
He said, I'm going to get her, and then I'm going to come back and get you. That's all I'm asking.
I'd like to see an offer of proof. This is a surprise to me that he has this kind of evidence along these lines. It's not contained in any of the discovery, and pursuant to the discovery order, he hasn't submitted it to me.
I think it's in there.
It's not.
But as to Loretta Winberg, her statement said that he threatened her while looking for his wife and said, where is she? I'm going to get her, and then I'm going to come back and get you.
Well,
I think that if you want to try to get any of these things in by asking him if he said it, we better take it up in chambers. For example, if he denies it, then you will want to bring in these people?
Probably yes.
I think that's what
he should have done originally, and my motion for a mistrial still stands because he did it in front of a jury, and now I look like I'm suppressing evidence or something.
Well, I think the protective order had to do with statements that the victim had made to other people, did it not?
Well, that was my understanding.
Yes, okay, I wish counsel would do these things in a more fair fashion than make me get up and object in front of the jury, if he would be more fair about it.
Just a minute. I resent this because I think both His Honor and I are under the impression that the protective order was dealing with a different area. And I don't know if it's unfair to ask him about threats he made.
Okay, apparently it doesn't come within the exact wording of the protective order, so that is invalid as to the mistrial. If he's talking about threats made to these witnesses, that is not covered by the protective order, and I'll concede that. But any further discussion along this line, I think, ought to be taken up in chambers. This is all news to me, and I object to it coming out in the basis that it's a violation of the discovery order.
Do you have a statement of Loretta Weinberg?
Yes, and that statement consists primarily of statements by the victim to her about threats that Mr. Jackson made and the subject matter of the protective order type stuff. There is nothing in there that I can see that I recall. I haven't looked at it for a few days, but as I recall, there's nothing in there about threats he made to her. I'd like to take a minute to look at it, but I'm pretty sure it's not here. This is new. I don't remember anything about this.
Well, I recall, I can't say certainly that it's in there. It may have been in my conversations with her, telephone conversations we have had, but if the court and counsel wish to take this up in chambers before we go any further, if that's the desire, I won't argue with that.
All right, I'll deny the motion that was made. I'm wondering if I should just let that last question stand or make any comment in front of the jury.
Could you read the last question back? I forgot what it said.
Referring to the conversation with Loretta Winberg,
I would just as soon move to strike that question.
I'll say that I strike the last question, and I'll tell the jury that I'm doing that. And then if you want to get into this area, we could do it in chambers.
can we do that at the recess so that we have time?
Yes.
Okay, thank you.
The court strikes the last question that was asked. It's not part of the record.
So is it fair to say, Mr. Jackson, that your reaction to your wife leaving was one of anger?
I would say I was upset.
It was a portion of that anger.
If that's the definition, it would be.
Pardon me?
I said it's all according to how you use the word upset.
Well, were you upset in an angry way?
Yeah, possibly.
Do you remember?
Objection. He just answered that question, that possibly he was upset in an angry way. He's already answered the question. Obviously, he remembers.
It sounds to me as though he might be guessing or speculating.
Yes, you can pursue his last answer a little further.
Do you remember your attitude?
I was somewhat angry, yes.
What did she take with her when she left?
My little girl.
What else did she take?
The trailer, the camper, the truck and the shell and other things that were in the house.
What other things did she take?
Oh, just things that you have in the house, not the furniture, but some mementos and things that we both liked. Nothing too great out of the house.
And she left quite a bit behind. Is that also true?
Yes, she left stuff behind.
Well, she didn't take any of your tools or anything like that, did she?
Pardon me?
She didn't take any of your tools or any of your personal belongings, did she?
Well, a few things.
For example, what did she take?
A picture I was quite proud of.
A picture?
Yeah.
Was that something that you had acquired during the marriage?
Yes.
Okay, and what else did she take?
Oh, I don't know what she took. I wasn't there, but whether she took them or the boys took them, I don't know. It was gone. I don't want to say she took them, I'm not sure, but some of the things were gone.
Was there at least enough behind to load up a large truck?
Oh, yes.
How long after Levita had left did you get the letter from Sissy saying with the postmark?
I really can't remember when we got it. It was after they left.
Well, maybe there's a postmark on it that says that. Now, the first notice was on the 23rd. That would have been 5 days after she left.
Yes, if that's what it is marked. I know it was after she left. I know it wasn't too long.
I see, okay. And there didn't appear to be any effort in there to hide where they were. It said, we're up north.
I got the impression from that letter that Sissy wrote it and mailed it all by herself without her mother knowing.
Why did you get that impression? Well, the way it was folded up, and I believe it was a 2-cent stamp, but I'm sure if I'm right, and they sent it on down, was it that impression?
Yes, well, not early. I didn't pick up the registered letter right away.
But that told you pretty early on where she was, is that right?
Not too early. I didn't pick up the registered letter right away.
Okay. But do you remember when it was that you called Mrs. Laurie?
Well, it was in the process when I was trying to find her, locate my wife and my daughter.
Was that before you got the letter?
I don't know.
Okay. And do you recall getting angry to Mrs. Laurie?
Yeah, we talked about it.
And you heard Mrs. Laurie testify that you said to her that, as I recall, as closely as I can quote Mrs. Laurie, you told her that goddamn daughter of yours is going to pay for this. Do you recall saying that?
No, I don't recall saying that.
Are you saying, could you have said that?
Objection, Your Honor. He says he doesn't remember, and whether or not he could have is speculation.
Yes, I'll sustain the...
Okay, tell who you are.
I am for the defense, Mr. Churchill, Churchill.
I am second defense, Mr. Walker, Walker.
I am the witness.
I am plaintiff's attorney, Mr. Beeman, Beeman. Okay, and we're starting off with questions by plaintiff's attorney, Mr. Beeman. Ready? Have you been to the site of where the accident of this lawsuit is about?
Yes.
When were you there?
I was there one day in December. I didn't write down the date, and then I was there again yesterday.
When you went there in December, who did you go there with?
I went there with my attorney, Ray.
And anyone else?
No.
Did you meet anyone there?
No.
How long were you there?
Probably about 30 minutes.
What did you do while you were there?
We looked at the position of the pole in question, or where the pole had been. We looked at the curve of the road. We looked at the embankment adjacent to the pole, basically just looked at the site, took some measurements, one of which is the document that you have that Ray furnished you.
Did you do anything else there?
We looked at the obstructions alongside the road and various things along the road in the general area, but that was not on site per se.
Anything else?
No,
Did you take any photographs?
not the first trip.
When you were first contacted about this case, what were you told?
Object to the extent that you're seeking conversations between John and myself on the basis that it's an attorney-client privilege.
You're right, and that's what I'm seeking, and I will tell you the reasons why I'm seeking that. Normally, I wouldn't be entitled to that, but I think in this situation, you have declared him as a retained expert or the equivalent thereof, and therefore, I don't think the attorney-client privilege applies. I think that he's not your client. He's a retained expert, somebody who is being paid to testify, and I don't think the attorney-client privilege attaches to that.
Let's go off the record on this.
Okay, let me ask you this. When you were first contacted about this case, what instructions were you given?
You mean the very first time I was contacted?
Right.
To the best of my recollection, I was merely asked to visit the site and talk about it with Ray.
Since then, have you been given any other instructions about your role in this case?
Do you understand the question?
I'm not sure what you mean about my role in the case.
You understand that you have been selected to testify in this case?
Yes.
All right. But what is it that you understand that you're going to be testifying about?
My understanding is it would be testifying as to the location of the pole and why it was where it was, I guess.
Have you ever had occasion to read the notice of the deposition that we are here about today?
No.
Have you ever been told to do anything in preparation for giving the testimony that you will be giving in this case?
Other than review the pertinent documents, no.
That's the limit of your instructions?
I don't know if he suggested that if I was out there, I might want to take some photos. I wasn't instructed to, but a suggestion.
Were those instructions presented to you orally or in writing?
Orally.
Have you received any correspondence about this case?
I received a fax covering with a copy of the document that we furnished you. I also received a list of BSPs that they thought were pertinent.
I think you said you received a fax along with a document that I have here.
Well, the document was faxed to me. If that is correspondence, then that's what it is.
Well, let me ask you this. Are you making reference to Plaintiff's Exhibit 3, 4, or 5?
Plaintiff's Exhibit 3.
Okay, I understand from your earlier testimony that you...
Excuse me, sorry. What one is the I gave? I was incorrect on that. It's Plaintiff's Exhibit 5 that I got on the fax. Excuse me.
Thank you. In preparation for this deposition, did you receive any other documents?
I received this document. That's just to see, it showed the road. We were trying to find the location on the document. That's Exhibit 4.
In particular, did you review any documents that pertained to the moving of this telephone pole after the accident in question?
I reviewed a routine order that showed it being removed
When did you do that?
yesterday.
Mr. Churchill, I ask that you produce the document the witness has reviewed.
I'm going to produce the document, but I'm going to again state my objection to the production of the document and to the admissibility of the document at trial on the basis of the document is not relevant and is not calculated to lead to admissible evidence in this case.
I understand, thank you.
While he's doing that, are all these documents stapled together, Exhibit 4?
Well, that's Exhibit 5.
I mean Exhibit 5, excuse me.
Thank you. Would you please mark these as the plaintiff's next two exhibits in order? We now have 7 documents that have been produced that you reviewed in preparation for this deposition. Have you reviewed any additional documents?
No.
Excuse me, other than the BSPs that he already referred to?
Yes, that's correct. Let me ask you about the BSPs before I forget.
Yes.
How many BSPs did you review?
I didn't keep track of the count.
Do you have a best estimate as to how many you reviewed?
5 or 6.
I have here 5 separate documents that the phone company produced in response to a set of interrogatories which we propounded, okay? I would ask that the court reporter make these 5 documents as plaintiff's next exhibits in order. I would like to show you what has now been marked as plaintiff's 10 through 14 and ask if you can take a look at those, please.
Look in detail or just verify that they're the ones that I reviewed?
Just to verify at this time that they are the ones that you reviewed.
Yes, those are the ones.
Okay, did you review any other BSPs other than these?
I looked to see if any others applied. I found none that applied.
Where did you look for those?
In our company library,
That's located where?
510 South School Street.
And what was the purpose of your reviewing these BSPs?
Other than what he has already stated?
I stated before that it was to see to verify the proper location of poles based there, and if there's a question about the pole location, then a standard procedure would be to look to see what the practices say that we should be doing.
Did you find that the pole in question had been placed in conformity with these BSPs?
Yes,
I would like to show you plaintiff's exhibit number 10 and ask if you could point out to me which portion of that BSP applied to the placement of the particular pole that is the subject matter of this lawsuit.
we're referring to plaintiff's exhibit 10. Actually, section 1.04 would apply. The entire section applies.
2.03.
2.02 and 2.03. It's difficult to pin it down to sections when the entire practices actually govern our placement of the poles. It's difficult to pin it down to one little section in any one practice.
Let me ask you this. Are each of these documents, plaintiffs 10 through 14, are each of these referred to separately as a practice?
Yes,
On the front cover of plaintiff's exhibit number 10, the date is somewhat obscured in the photocopying process. I ask if you could tell me what date this was issued.
I can't read it on your photocopy, and I do not have another copy.
Do you have a memory as to when you first saw this?
No,
How much time did you take in preparation for this deposition in reviewing these 5 BSPs?
as part of the previous question of how many hours I spent on this, that's part of the 14 hours,
I understand that.
probably 2 hours.
In calculating the time that you have put in on this and preparing to testify, does that include travel time from your job site to the location
Yes.
of the accident?
Yes, it does.